If you are a business in Australia, then most likely you use a standard type contract when you supply your goods or services. Now, it's most likely that that standard contract is subject to the unfair contracts regime under the Australian consumer law. And so then the question that's been put to us is, well, what is an unfair contract term? All right, well, we will get into that. So it's Simon here from the Contract Company. Contracts, it's what we do all day, every day. We also run a charity, Ask a Contract Lawyer, where people can ask us questions and we will answer them. So let's get into it. Unfair contract terms, what are they and what do they look like? Well, the first thing to bear in mind is you need to understand if you're going to be caught by the unfair contracts regime and under the Australian consumer law. So if one of the parties to your transaction is a small business, i.e. a business that employs less than 20 people, and the upfront price payable under the contract is no more than $300,000 or no more than $1 million if the contract is for more than 12 months in term, then you're most likely subject to the unfair contracts regime. So let's step through it. What sort of contract terms can be found to be unfair? So if there is a unilateral variation clause in the contract, so that is a clause that gives one party the right to vary the terms of the other party without notice and without correspondence, or without the other party being able to reject or negotiate the variation, then most likely that clause will be unfair. Actually sounds unfair when you talk about it, doesn't it? Okay, let's move on. Number 2. So if the contract has an automatic renewal clause where your client or customer has to give notice to cancel the contract within a specific period, and that you as the provider of the services or goods are not required to give any notice about the imminent rollover of the term, then that could be found to be unfair. Now, just bear in mind, you can have a contract that has an unlimited term, i.e. it just renews automatically if there is a termination for convenience clause. So the contract just runs ad infinitum, i.e. forever, until one party is able to terminate for convenience. Then that sort of clause will be okay. Because when you think about it logically, if and when you want to get out, you should be able to get out, and so that you're not bound by a term that just goes on forever and ever. So if you've got the ability to terminate for convenience and can get out of the contract, then automatic renewal clauses will not be unfair. But in saying that, if there is an automatic renewal clause where your customer or client has to do certain things by a certain date, and if they don't, then the clause rolls over, then most likely that'll be unfair. Okie dokie. Extraneous documents. So if your contract refers and imposes obligations from other contracts that you aren't obligated to provide, or you don't provide to your customer or client, and those other documents impose obligations on your customer or client about which they are not aware, then most likely, guess what? That will be an unfair contract term. Which makes sense when you think about it, because if a party is signing a contract, the party should be able to ascertain all the terms and conditions and all the obligations on them before they sign the contract. And if those obligations are contained in other documents and they can't see them, then guess what? They're probably not going to be bound by them. Some clauses that limit liability can be found to be unfair. So if the contract limits the liability of you to your customer or client, or that they require that your customer or client indemnifies you, including where you or your agents have caused or contributed to the loss, then that is going to be found to be unfair. Because if you've caused or contributed to the loss, you shouldn't be able to seek an indemnity from your customer or client. Okay, next one, disproportional termination terms. So if the contract permits you to suspend or terminate the contract for minor breaches, but your client or customer doesn't also have corresponding or similar rights, then that means that termination clause is disproportionately favourable to you as the person who put out the contract, and therefore it will be found most likely to be void. So the simple way to avoid this one is just to have a balanced termination clause. So if you can terminate by giving 30 days notice, then you should allow your customer or client to terminate on the same terms, i.e. if they give you notice of 30 days. Okay, let's move right along. The next one is termination payments. So if the contract indicates that if you terminate the contract, and I'm using you to be the business, if you, the business, terminates the contract, and when you do that, your customer or client must pay a termination fee to you, and the amount of that fee is unilaterally determined by you, and the amount that you end up determining is disproportionate to any loss you've suffered, then guess what? That ain't going to be found to be reasonable or fair, i.e. that will be an unfair contract term. Which makes sense reasonably, because any loss that's payable under a contract, you should be able to ascertain reasonably and defend why the cost or the loss is what it is. And so any sort of disproportionate claim, and then you seek payment for that, is just unreasonable. Okay, let's have a look at the next one. Some contract clauses about what happens when the contract ends can be found to be unreasonable. For instance, if you are in the goods provision game and your contracts provide that following the minimum term, the customer or your client must either retain those goods and pay you the shortfall between the residual value and the market value, and guess what? You're the one that determines the residual value. Sorry, the market, if you're the one that determines the market value, and the title and the equipment does not pass to the customer at any time, then have a guess. That's most likely going to be found to be unfair. Okie dokie. Next one is an irrevocable offer. So this is basically a clause that says that on signing the contract, the customer or your client makes an irrevocable offer to you, but you're not bound until your customer satisfies some sort of acceptance or conditional acceptance criteria. Then that is going to be found to be unfair because they are giving you an irrevocable offer and you're doing nothing in return, and yet both parties have signed the contract. Rightio. Next one is non-reciprocal provisions. So this is a pretty standard one, and that is flash legal jargon. Actually, it's not even that flash, but basically it's jargon for saying if the contract is not balanced, in other words, if obligations placed on your customer or client aren't similar to obligations placed on you, so that they're disproportionate or non-reciprocal, then guess what? Potentially unfair and can be struck down. Now, I did say I wanted to run through 9 unfair contract terms, but guess what? Here's number 10. And it's a good one to end on, unfair payment terms. So if your contract contains payment obligations which arise irrespective of whether you provide the relevant goods or service, then guess what? That clause, or those clauses, are most likely going to be found to be unfair. Makes sense, doesn't it? So if you're a business and you use a standard contract to provide your goods or services, which you should, to your customers or clients, you just need to be careful that the terms or clauses or conditions you put in your contract are balanced and fair and reasonable. And if you can do that, then you are going to have a contract that is not unfair and that will not be found to be breaching the unfair contracts regime that's set out in the Australian consumer law. Anyway, I hope that's some information that helps. If you have any questions, please feel free to get in touch. Thank you.